some movement on another deportation case, the 5 Tren de Aragua guys who were initially deported under the Alien Enemies Act. They've been 3 of the 5 have elected to pursue their habeas corpus privilege in Texas federal court, which is where they all should have been in the first place. Everybody has said from the beginning that these guys are entitled to a habeas hearing in front of a judge where they have the opportunity to challenge whether or not they fall within the scope of the proclamation under the Alien Enemies Act, under which they could be summarily deported. Because we don't want to deport people under the proclamation who don't fit the scope of the proclamation. Nobody wants that. And the scope of the proclamation is you're a member of TDA, you're 14 years of age or older, and you're not a U.S. citizen or green card holder. So if any of those things are not true, if someone's been grabbed under the proclamation and it turns out they're not a member of TDA, or they're under the age of 14, or they're a U.S. citizen or green card holder, they ought not be deported. And everyone grabbed under this proclamation should have the opportunity to make that argument. Now, I would say that the argument does not need to be made in person. This could just be a matter of paper filing, routine paper filing by the federal government. If the federal government files an affirmation or an affidavit with the federal court under oath, an ICE official, it tests the government has good reason to believe this person's TDA, 14 years of age or older, and is not a U.S. citizen or green card holder. That's it. It's over. That's the due process the person's entitled to. So this could be purely be a paperwork process. It doesn't have to be every TDA member gets paraded in front of a federal judge for their habeas hearing. There's lots of habeas hearings that happen that are just paper. There is no court appearance, certainly in the criminal context. 3 of the 5 guys are in Texas now. And if it turns out that they can rebut the government's argument that the government has good reason to believe they're TDA, at least 14, and non-citizens, non-resident aliens, permanent resident aliens, they should be kicked loose unless they can be deported on some other basis. But who thinks they're going to be able to prove that? Does anybody think the government didn't take care to ensure that these guys qualified for deportation under the appropriate due process? And this is it. This is all the due process these guys are entitled to under the Alien Enemies Act. So they're going to get their habeas and then they're going to be sent off to CCON. And that's how all of this should be handled in the first place, in a Texas federal court doing a habeas hearing. If they ask for a habeas hearing isn't done by default. A Cardinal says, did you hear James Carville's interview where he likens Trump supporters to Nazi sympathizers? It's like they're trying to incite violence. Yeah, the left is trying to incite violence. There's no question about it. Question, does a deportation order have any statute of limitations? No. Statute of limitations exists in a very specific context and a very specific reason. So a statute of limitations would involve like a criminal offense, say, I don't know, robbery. If someone is believed to have committed a robbery, you have to charge them with that crime, the state does, within a certain period of time. Often it's like 3 years, although of course it varies by state. This is the same with civil litigation too. There's a period of time in which you have to bring the action. And the reason we have these policies is because we all understand that if something's claimed to have happened and then a sufficient amount of time passes, the credibility and the provenance of the evidence, either for or against that, becomes very tenuous. Memories change, physical evidence degrades, witnesses die, and it just gets to the point where the quality of the evidence is degraded so much that we can't have faith in the process anymore. So every crime in America but for murder has a statute of limitations for that purpose. And most civil actions have a statute of limitations too, like for personal injury and so forth. That's the reason we have a statute of limitations. It's because the quality of the evidence degrades. So you can't trust the evidence to get you to a reliable, adjudicated conclusion at the end. That's not the same with an order that's been issued. A gang order, a gang affiliation, or a deportation order that's been issued is issued on quality evidence. The evidence there is not old. It's the best evidence available, and a conclusion is reached. After the conclusion is reached, it doesn't matter what happens to the underlying evidence. It's already served its purpose. So no statute of limitations. Phil says Judges Boasberg overseeing the TDA Alien Enemies Act cases and Paula Zinnes overseeing our friend Garcia are what would have been called back in the 60s ugly Americans for their arrogant, chauvinistic, smug, superior attitude towards other countries. Yep. This is not a matter of extradition. Clay asks about extradition. Extradition is when we we want to charge someone with a crime and try them, and they fled to another country. So we have treaties with other countries where we say, hey, we have reason to believe this person committed a crime. We've indicted them. We want them here for trial. And the other country agrees to send us the person under those conditions. The U.S. doesn't want him back. That's rather the point. So this is not anything like an extradition treaty. We're not asking for the government, the executive branch is not asking for anybody to come back. The Article 3 judicial branch is trying to impose that. Coding light, $5. My main problem with this is what if another country in such an order says no? What would the executive branch do? Send a SEAL team in? Start a war? Yeah, so when this judge, Paula Zinnes, orders the White House to effectuate Garcia's release to the U.S. or be held in contempt of court, and that's always the consequence of not obeying a court order, she's ordering them to effect. That means make it happen. Make it happen, or we're going to hold you in. I will hold you in contempt. Me, an unelected black robe, tyrannical, inferior district trial court judge, will hold in contempt the Article 2 executive branch president, elected by the whole of the people to exercise their political will. Seems like a bit of a mismatch there. But yeah, Trump doesn't have any way to effectuate this. I mean, at the most, he could ask. And if he asked, they might say yes. But that's engaging in foreign policy. The courts don't have the authority to order the president to engage in foreign policy. And the American president certainly cannot compel the independent sovereignty of El Salvador to do this. What, a military invasion? As Coding Light suggests here. It's just crazy. What's the status of Judge Boasberg's contempt of court? He kind of stepped around it. He hasn't held anybody in contempt. He offered to the 5 TDA guys that if they had other grounds for thinking that he had jurisdiction over their case, if they had other arguments they want to make in his courtroom, he's going to let them do that. So the basis they were arguing for, that didn't work. The Supreme Court said that's not going to fly. And the habeas corpus argument only gets them back in Texas. But when they initially filed, they had raised like 8 different arguments for why they shouldn't be deported under the Alien Enemies Act. And it's in theory, they could still try to argue one of those in Judge Boasberg's court. You know, those are obviously even weaker than the one they already lost on. So at least 3 of them have opted out of that. They went to their habeas hearing in Texas. So I'll look for it and see if there's a meaningful update there. Try to see if there's anything interesting going on. If you're ever compelled to use force in defense of yourself or your family, the good news is that if you defended lawfully, you can be very hard to convict. But did you defend lawfully? Because if you don't know where the actual legal boundaries for self-defense are, it's the easiest thing in the world to innocently step over them, and now you're extremely easy to convict. Good news. In just a single day, you can become an expert on the law of self-defense and make yourself extremely hard to convict. On Saturday, April 26th, I'm holding one of my only twice-a-year full-day law of self-defense advanced classes. This class is taught live by me and live streamed to you. It teaches you everything you need to know in one day, and there's plenty of opportunity for personal Q&A with me as well. Even more good news, when you register today, you save yourself 50% off the standard registration, but that discount ends soon. Your 50% discount and many more details on this advanced class are available just by pointing your browser to lawofselfdefense.com/advanced today. And I'll also drop that link in the description. I look forward to seeing all of you there.